Hi, well, first things are first. The date today is the 11th of October, and I've had quite a few developments. Now, once again, I contacted the Express having received a letter. Before we go into that, I'd just like to qualify something. My friends that have been looking at my postings have been saying, you say what you say very well, but kind of look a bit scruffy and they're not shaving. But I want people to remember a couple of things. A, I'm not working right now. I'm a qualified engineer. I'm multi-skilled. I'm an engineer electrically, engineering and plumbing and heating. I've been a tiler for over 12 years, full bathroom installations. Yeah, I can't find work just now. I live on approximately £70 a week for my food and other essentials, electricity. And that's fine, whilst I'm not working. I do have a stepdaughter who lives not that far away from me, and I use this, which means I can't get a clean shave, but I can buy 20 batteries for £1, and this takes one of those. So that's how I groom. As for my hair, well, I don't get my hair cut as often. I could go and borrow my sister, who's a hairdresser, but she works all the time. And besides, when it comes to my hair, I say it's better than Boris Johnston's mop. So there we go. But anyway, remember that I said about the accusation of Sergeant McMahon at a meeting on the 8th in his office at Hamilton Police Station, that once categorising the facts for him that indeed what I tell him could be child abuse by the Scottish Government, but it would be unlawful, not illegal. Interesting, when I spoke to a reporter from a main newspaper, he said, well, some things that start as unlawful can become illegal. And he is right. But what's interesting is, as you said, I told you, I request information from Sergeant McMahon and Inspector Jennings, who are handling my complaint about police investigation under the process which you can apply if you're involved with police and you're not happy, called Professional Standards Unit. Another example of, we do have a democracy that should work if all the stakeholders, all those who we entrust to perform those tasks, do it diligently, without fear of prejudice and with all the information available to them. So here was one of the suggestions, was that I get an FOI request. So I put in an FOI request for information regarding incidents that would have been compiled by the police unit at Scottish Parliament. Now, I'd phoned the Scottish Parliament and asked them about Miss McKerrow's interaction with them, and they said, well, you need to make an FOI request. So I did that. I did that in the context of this larger request for the 6 police officers. That was being handled, that 6 police officers at 3 meetings with my SNP representative and our staff were being handled, and I still haven't had a reply yet. It's now 9 days since it was told that it's been sent. It's been sent off by the author, and it still hasn't reached me. And the 17th of October, when I go back to court to face Sheriff Vincent Smith, is hurtling nearer and nearer. At the same time, she says, well, if you want information about what was held by the Parliament office from police, you'll have to make an FOI request for them. And I did that. Now, let us look at what I got back. This is dated the 7th of October, so it took quite a bit. It's got our reference IM-FOI-212014-1912. And it's addressed to me. It's headed under Sir Stephen House, QPM Chief Executive, and from the FOI Central Processing Unit at 173 Pitt Street. Freedom of Information Act 2002, subject specific incident reports, numbers made to Police Scotland. So that's talking about the phone calls and any incident numbers that would either indemnify the accusations made and statements made in Parliament, in the court, during my prosecution by the witnesses who were defaming me. And here what we have. I'm going to show you it rather than just read it. I refer to your email dated 12th September 2014 regarding the above, which has been handled in accordance with the Freedom of Information Act 2002, in terms of Section 18 of the Freedom of Information Scotland Act. Police Scotland can neither confirm nor deny that old adage that it holds the information requested by you. However, if the information was held by the service, it would be considered exempt in terms of one or more of the exemptions. So there's lots detailed in Section 18 of the Acts which are listed below. Section 18 of the Act also provides that there is no requirement on a public authority when issuing a refusal notice in terms of Section 18 to state why the public interest in maintaining that exemption outweighs that in disclosure of the information. Nor is there any requirement to state why the exemption applies insofar as that statement would disclose information which would itself be exempt information. Now, none of that there is the Act. That's just them giving you their overview. And then it says, so there, this should not, however, be taken as conclusive evidence that the information you have requested exists or does not exist. By way of explanation, you would think anybody else would just give you the information. By way of explanation, I do not believe that the Parliament ever intended that this kind of personal information would ever be captured by a request under the Act. Accordingly, I do not intend to process your request further at this time. That said, although in the instance the service can neither confirm nor deny that the request information is held, in general terms I can advise that if it is held it would be exempt in terms of Section 38(1)(a) of the Act, but doesn't go out to tell us what that Section 31(8)(a) is, and interestingly Section 38 of another Act is what I've been charged under. As if held, it would constitute personal data and its release would breach the requirement to process personal data fairly as laid down by the first Data Protection Principle in Schedule 1 of the Data Protection Act 1998. I appreciate that this response may be disappointing, however I feel that it is important to emphasise to you that the Act is in essence applicant and purpose blind. By this I mean that the information disclosed under the Act would be available to any person so requesting it. In instances such as this, it is recognised that harm exists even in confirming or denying the public domain the information is held. So it's saying there that you can make a disclosure, but it has to be a personal request for data on yourself. So what should we do, ladies and gentlemen? Should I go to the judge and say, well, give me this? Because a judge can give the order. Remember I showed you the Information Commissioner's notice. I've also sent it off the Information Commissioner. They've got back and said, well, you've got to go through the proper channels before we can look at it. I'm going straight to a judge, and I will go straight to the judge on the 17th and say two things. A, I got a letter from him saying that my appeal was now out of time and was therefore closed. Well, I've been trying to get this information since before that case was concluded. I've come up against barriers all the time. Now this, and as I said, my perjury charges against the 4 key witnesses. I will be going to Sheriff Vincent Smith and asking for specifically his authority to give a court order to release this information, as would be my right if I had, in the case of my information request for compliance, had pursued it, which I would have had to have had at least £10,000 to do, by the way. So the only way I can even get to enforce such a thing of my own volition is because I'm facing 2 years in court in jail. And that's what we're looking at, 2 years in jail. Quite sick. But anyway, I'll ask the sheriff for him to get authority to get these 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, at least 10 police officers, and at least 1, 2, 3, 4, 5, at least 5, if not 6 incident numbers. Then we obviously have the voicemail data, where specifically in the summary of evidence of the police, which was the spine of the decision by the Procurator Fiscal to proceed with the case to the courts, Within that summary of evidence, we'd also require the voicemails, all the voicemails. Basically, give us a lot, give us the voicemails to the BBC from my number. I can assure you that I can't prove explicitly, but I'm telling you, never mind under oath, but under public statement here now, that every time, for my own protection, for this kind of nonsense, I always phoned from my home number, which is registered under my business back at my home that I left after I was put in jail. And I did that to protect my family, my legit family, my partner, daughter, Chloe, and her mum. And I want that information because they all relate to that phone number. That's my home number. It's under my business at Bonnie Tyler. Now, we also have the voicemails that would be allied to that. We'd have the call register, so we can know specifically how many times I called. Then we have Miss Polling's lies in court. She openly told the court that she never ever, from the day she met me, at a meeting that she arranged after my protest at the BBC Scotland's atrium, where I was not within 25 feet of any other person, right? So no one was under personal threat, and I didn't swear, something else that's in the summary of evidence that I swore. That's why I need these three officers on the P&C check, because then I can timestamp that. They'd carried out that check, and therefore will be able to identify themselves from that, and that is my personal data. But I'll take what it does say in there and make the personal request. But there's more pages there, there's actually more since I replied to them. And that's what they've got to square. I don't want this posting to be too long, and I'll come back to that. But essentially, we also have Sam Polling lied to me. She admitted it in court, so I can raise a complaint over her conduct to her management in the BBC. And also, that proves that she can prove that out with that by the email she sent me of some colleague that she knew who was an independent journalist. I have those emails myself where she says, well, we'll not be taking it any further now. So, Panorama Scotland were genuinely looking at it, and it was pulled. I mean, I haven't used these words. It was spiked, it was pulled. These are terms given to me by this journalist. So, either she did lie, or either way, she misled a member of the public. And of course, where was all this concern for the 9 months? This is all relevant to the idea that I stalk people. When you go to elected representative, you can't stalk them. Not by A, going to appointments at a pre-arranged date, B, not by phoning them saying, well, here's what I want you to do, say I can take this no further unless you bring up other things. Note the letter that I posted from Miss McKerrow. Well, once they tell me they won't do it this way, I have option B, C and D, and by trying to vocalise them via a telephone, again cannot be construed as stalking. Essentially what Sheriff Smith has done is set a legal precedent where you can be criminalised for trying to get representation from your elected members. I'm sorry everybody, I didn't mean for him to do that, but do you blame me or do you blame the sheriff? Or do you blame the perjurers, the liars, the fraudsters that came to court and they told such terrible things, such lies, without corroboration, without evidence other than their own collusion, which the evidence which has not been released would not only prove them wrong, but prove that they conflict with their testimony, i.e. they perjured themselves. I'll come back to this in a minute. Keep posted and please share.